Now, the conversation surrounding our nation electoral process has evolved from a policy debate into what many are now calling a saga, protracted and complex series of events with high stakes for the future of our democracy. Now, allegations, counter-allegations, legal challenges and heated parliamentary exchanges have dominated the headlines, leaving many citizens with pressing questions. What began as a call for reform has unfolded into a multi-layered controversy, raising fundamental issues about transparency, trust, and the very architecture of our elections. Now, today, we move beyond the headlines to our discussion segment, where Electoral Reform Saga will be analysing matters arising. We'll dissect the key flashpoints that have emerged from this ongoing saga. What are the legal and constitutional implications of recent developments? How is this affecting political cohesion and public confidence? And crucially, where do we go from here? Joining us now via Zoom to unpack these critical questions is Abdulkareem Musa, a lawyer and public affairs analyst. Mr. Musa, welcome and good morning.
Good morning, and thank you for having me.
Yes. Thank you very much. Now, looking at all that is going on when it comes to the electoral amendment bill, now, can you shed some light for us so that Nigerians can understand so far what has been changed, what has still remained, and what issues there is when it comes to the electoral amendment, and have they so far made changes that can aid in making sure that this bill or elections in general do succeed?
All right, thank you. Good morning once again.
Good morning.
You see, I'd like to begin by saying that the fulcrum upon which the democracy of any nation is founded is upon free, fair, and credible elections. So, to determine whether a nation is practicing democracy, what you must look at is the system surrounding the elections in that country. What we've had in Nigeria over the years is a situation where elections have been conducted without due regards with the electoral laws, in breach of the provisions of the electoral laws. Elections have been conducted in manners that can be described as not being very fair, free, and credible. And this has led to several amendments of the Electoral Act. And in recent times, sometime in 2018, the INEC had a meeting with the NCC and some other stakeholders to introduce electronic voting system in the Nigerian electoral system. Unfortunately, because of the proximity of the time that meeting was held and that agreement was reached, INEC could not implement that electronic voter system in the 2019 elections. And that was why there was an amendment of the Electoral Act in 2022 such that they would give effect to electronic voting in 2023. When you examine the act, you would understand the body language of the Electoral Act as attempting to introduce an electronic or digital system of election in our electoral system in Nigeria. Unfortunately, after the election, there were a lot of glitches and a lot of malpractices associated with the election. And then a lot of people began to wonder what was now the need for all the funds allocated for electronic system to be introduced in our electoral system. So there was an outcry, and Nigerians are aware how BVAS was introduced in the election, but at the end of the day, BVAS machines did not seem to have any impact on the outcome of the elections. And so there were further yearnings for amendment of the Electoral Act. And in the amendment of the Electoral Act, Nigerians clamored that this electronic voting system, which was previously under the 2022 Electoral Act, in the guidelines of INEC, should be taken from INEC guidelines and made a provision in the Electoral Act itself that could be penalized, such that if a presiding officer does not transmit votes electronically, such a person should be punished. That is what, at this time, the Senate has rejected. That is giving regards to the elongated period of time that the Senate had been negotiating, deliberating, and arguing over this matter. So my contention is that what we are seeing is that Nigeria is at a crossroad. This is a test to the ruling class and our political leaders as to whether they are ready to change the narrative of the electoral system of our country, or that they are ready to make laws that would only represent their personal and primordial party sentiments. Now, if I may go further, the germane question around our electoral system is that the world has moved on, that in other parts of the world, elections are conducted electronically. In countries, smaller countries like Congo, elections are conducted electronically. How much more a country like Nigeria? And does the law that we have not already encourage electronic voting system? Many have argued that the law does not, but it is my position and many other Nigerian lawyers that with the law that we have, if it is the will of INEC and other stakeholders to conduct electronic voting in Nigeria, then they would. I will take you to section 60, subsection 5 of the Electoral Act. That provision provides that all presiding officers in polling units must transmit the total number of accredited voters and total number of vote cast in accordance with the prescription of INEC, the commission. And if you want to know where the prescription of INEC is located, then you have to visit the INEC guideline. In Article 38 of the INEC guideline, it is stated, and I would like to make reference to it from the Electoral Act, which I have here, that on completion of all polling unit voting and result procedures, the presiding officer shall electronically transmit or transfer the result of polling units direct to the collation system. The presiding officer shall use beavers to upload a scanned copy of the election result to INEC portal. The presiding officer shall take the beavers and the original copy of each of the forms in temper evident envelope. So when you read these sections together, you can make an argument that if the courts are interested in encouraging electronic voting system, then what other law are we looking for in the face of these provisions that I've read? If the lawmakers and the judiciary are interested in interpreting this law in light of the need for electronic voter system, then what other laws are we looking for?
Yes, Mr. Musa, you spoke about INEC at this point. Now, speaking of the amendment, does the amendment expand or restrict the powers of INEC? And is that expansion at this point consistent with sections 153 and 160 of the Constitution? And, you know, a lot is going on in seeing and saying that INEC has been excluded when it comes to these amendment bills.
Well, you see, before amendments are taken, there are usually deliberations and stakeholders are invited to make contributions. And you cannot be making an amendment on a law that has to do with an agency of government like INEC and exclude INEC. Certainly, there has been the contribution of INEC. With what we have seen so far, the powers of INEC are being limited. When you mentioned section 153 of the electoral, I'm not sure that section is very correct. But the powers of INEC from the amendments that we are making so far, it seems to limit the responsibility of INEC. Meanwhile, Nigerians are yearning for an expansion of the responsibility of INEC. For instance, with the section I just read to you in Article 38 of the guidelines of elections, there is no punishment for a presiding officer who refuses to transmit or transfer election results. So what Nigerians were clamoring for was that impose a punishment, make it mandatory on INEC. That is, extend the responsibility of INEC so that we can hold on to INEC. We can hold on to somebody who refuses to transmit election results, who gives us the excuse that there was a glitch or there was a network. There was no network for him to transfer the result. Let there be somebody accountable for every procedure or process of our elections. That is what Nigerians were clamoring for. But for the National Assembly, the Senate, to reject this bill, that part of the bill, it shows a delimitation of the powers of INEC. And that is a concern because it leaves a loophole for intending criminals. It leaves a loophole for persons who have intentions of causing mischief in our electoral system. But if you may rephrase your question as to the particular section you're trying to refer to, then maybe we might give a better expression to the issues.
Okay, Abdulkareem Musa, let me digress a little from Hawa's question. Civil society groups and opposition parties have expressed concerns, and they have called this a betrayal of a public trust. How does this rejection affect voter confidence ahead of the 2027 polls?
Yes, it is not a lie that the action of the Senate has occasioned a deep erosion in the trust of the public in the credibility of the Senate, the credibility of the ruling party, and the credibility of INEC itself. So, in the face of this distrust, there is a likelihood that Nigerians will be discouraged in even participating in the process. If you look at the previous elections we've had in this country, majority of Nigerians do not participate in the electoral system. And it is not because they do not intend to participate, it's because participation in this process has been made, number one, tedious from the point of registering a voter. Number two, there has been a discouragement along the line of Nigerians having the impression that their votes would not count. And they do not just manufacture this impression. They have seen time and time again that in a lot of instances, the votes that the lawful vote cast in a polling unit would be different from the vote announced by INEC in collating the election result. So there's a deep discouragement that their votes will not count. Another very major factor that has discouraged Nigerians from voting in elections is issues of violence, intimidation, issues of buying of votes, so that a less privileged aspirant is already sure that insofar as buying of votes will be allowed in an election, his chances are limited. So now, in the face of all these factors that I've mentioned, what the action of the Senate has simply occasioned is a further distrust and a further erosion in the trust that the Nigerian people can repose in the system.
All right. Now, speaking of the sections that I spoke of from the Constitution when it comes to expansion or restriction of the INEC, that is sections 153 and 160 of the Constitution, and it says that it establishes key federal executive bodies, including the Code of Conduct Bureau, National Judicial Council, and the Independent National Electoral Commission, which empowers these bodies to regulate their own procedures with presidential approval, ensuring functional independence. Now, that aside, I was just wanted to clarify that. Now, that aside, when it comes to judicial processes, are there any latent constitutional conflict within the amendment that could render parts of it vulnerable to judicial challenges, especially now that the Senate has rejected a proposed 10-year jail term for buyers and sellers of permanent voters' cards, PVCs, and opting instead to retain the 2-year imprisonment while increasing the fine from 2 million to 5 million naira. So is there any interference when it comes to judicial processes?
Okay. Your question is a bit complex, but let me take it bit by bit as much as I can. Now, the issue of whether there are conflicts in election tribunals or the rules guiding them, there are a lot of contradictions and there are issues that require resolution. Let me begin from there. You see, the crux of an election is usually determined by courts, and there are special tribunals and panels set up called the election petition tribunals. Now, after an election, parties are required to aggrieved parties are required to institute actions after 14 days of announcing results. One of the issues that has bedeviled the electoral system is that parties are required to file election petitions. That is, if a party is aggrieved that the election did not go well, he should file a complaint, file a petition to the election petition tribunal within 14 days. In that 14 days, this aggrieved party would require materials from INEC that he's complaining about. For instance, if you are complaining that election was not conducted in compliance with the Electoral Act, or that the person who contested against you or who was announced did not have majority of lawful votes cast, or that the person who was announced was not qualified to have contested that position, documents that you would need to prove this thing resides with INEC. Most of the documents reside with INEC. There's a difficulty in obtaining these documents within 14 days. That's one issue that needed to be addressed. Now, that wouldn't have been an issue because I could go along to file my petition and then there's something called subpoena in law. This subpoena is an order of court requiring somebody to come and tender evidence in court. There are two types of subpoena: subpoena duce tecum and subpoena ad testificandum. That the court is ordering somebody to come and tender documents to support to come and tender some documents in evidence or give oral evidence. Now, we can rely on subpoena in election petition tribunals to order INEC to bring relevant documents and materials to prove or disprove an allegation that elections were conducted wrongly. Now, one of the major and fundamental problems associated with our Electoral Act is that while this principle of subpoena is well established in law, that where a person is in possession of materials or documents that are relevant to doing justice in a case, the court can order the person to bring it. When it comes to election petition, the courts have decided that you cannot subpoena INEC. And how did they make this decision? The INEC, the first schedule to the Electoral Act, provided that every person that must give evidence in an election petition tribunal must have a witness statement on oath. Now, you cannot obtain a witness statement on oath from a person you are accusing. That person is your adversary. If you are my adversary, I cannot come to you and say, come and give me a witness statement on oath and testify that you did not conduct election very well. That is why we rely on subpoena. Now that subpoena has been eradicated in election petitions, that even if INEC in previous times in the last election petition cycle, the INEC staff that were invited to come and give evidence, who did not have a witness statement on oath, and who could not have had a witness statement on oath because the petitioner who is complaining that INEC did not conduct election well cannot obtain a witness statement on oath from INEC. The courts disregarded the evidence of INEC that they brought on the grounds that these witnesses did not have witness statement on oath. That is a very huge lacuna in the Electoral Act that Nigerians were expecting that the Senate would amend to reflect the intention to do justice.
Mr. Abdulkareem, unfortunately, we're out of time at this point, but thank you very much for shedding more light on the Electoral Amendment Act.
Thank you so much for having me. Absolutely. Have a good day.
Thank you very much, Mr. Abdulkareem.